Hello. I am Yamato Sato, a lawyer. I am practicing as a lawyer in the entertainment sector, and among other things, I represent creators such as performing artists and performers. In my presentation, I will discuss the practical impact and challenges of the new Freelance Act on the entertainment creative sector, based on my experience as a practitioner. There are various issues that can and cannot be solved by the Freelance Act, as well as issues that need to be considered, but I would like to give an overview in the limited time of 10 minutes. I am concerned because although there are many problems that can be solved by the Freelance Act and it will have a positive impact, if guidelines, especially those focusing on the cultural and artistic fields, are not specifically defined, there could be confusion. Earlier, while listening to Mr. Takeda's lecture, I was thinking specifically in the light of my own experience. For example, if an actor has to redo a performance, how does the Freelance Act apply in such a case? I myself also sometimes appear as a commentator on television. On these occasions, I am sometimes asked to appear tomorrow. Mr. Sato, please appear on the show tomorrow, or I receive requests to appear on live television right after this, at 5 p.m. The Freelance Act imposes an obligation to deliver the details of the order in writing or otherwise. What happens if a written document is presented that clearly states the conditions for this obligation and, at the same time, time is limited? Is it possible to fully discuss the matter, even though the appearance is in an hour's time? Because of the lack of time, we will probably have to say, "Oh, I understand, I accept, I will appear with this." We also spoke earlier with Mr. Takeda about whether the Freelance Act applies to overseas businesses. It is applicable, he said. However, is it possible, if necessary, to impose penalties or other measures to ensure compliance when the ordering party is an overseas operator? I think there are issues in this respect as well. As noted on this slide, I believe that the Freelance Act will, to a certain extent, help to improve trading conditions and the working environment by, for example, increasing transparency and fairness in transactions, resolving late payment issues, and rectifying the working environment. However, there are some problems that the current regulations in the Freelance Act are not likely to solve in the performing arts creative sector. I would like to talk about this from now on. Of note, the Freelance Act will come into force in November, whereby reductions in remuneration will be prohibited. In anticipation of this, there is currently a movement to reduce freelance remuneration before the Freelance Act comes into force. If we reduce it now, the Freelance Act will not apply to us, so we are thinking of reducing it while we still can. I am receiving an increasing number of such consultations. The Freelance Act is also causing a lot of problems at the moment. As Professor Okada mentioned earlier, the multi-layered subcontracting structure is a characteristic of Japan's entertainment and creative sectors. Between the chains, there are often intermediaries such as agents and entertainment agencies. In this context, there is often consultation on the relationship with management offices. This is currently being investigated by the Japanese Fair Trade Commission. Some management offices are, of course, sound. However, a number of problems have arisen regarding management offices that are not sound. Specifically, it is not possible to terminate the management contract. For example, there are consultations regarding the inability to terminate the management contract, and problems such as, we are forced to attribute all deliverables, intellectual property, etc. to the management office, and as a result, they develop products using AI at their own discretion. In addition, problems such as unreasonable restrictions on the exercise of moral rights and acts restricting independence and transfers, which Professor Okada referred to earlier, are occurring. As pointed out by Professor Okada in his presentation, some of these problems can be solved by the Freelance Act, while others cannot. There will be some overlap with what Professor Okada said, but the first issue is how management offices are to be regarded. The second problem is that the Freelance Act does not provide for termination from the freelance side. The third problem is that there is also no legislation to ensure that remuneration is properly paid. Let's look at some specifics. The largest problem is with the entertainment offices. However, there are similar problems with agents. For both, the problem is that it is unclear how to characterize the intervening company. As Professor Okada explained, it is unclear whether the management office is to be regarded as a mere intermediary or as an ordering party. Needless to say, the Management Office wants to avoid the application of the Freelance Act. As Mr. Takeda explained earlier, if it is made clear that it is recommissioning, the Managing Office will have to pay the freelancer as a recommissioning operator, even if the client does not pay the office. In the cultural and artistic fields, this amount can range from several million to tens of millions of yen. For e.g. esport athletes, the amount of foreign prize money can run into the tens of millions of yen. In this case, the foreign companies do not pay, but if it is made clear that they are a recommissioning business, the esports management office has to pay the amount, which amounts to several tens of millions of yen. This would be a burden for the management office. So they asked me, Sato-sensei, can you draw up a management contract so that the Freelance Act does not apply to us? Thus, how management offices are regarded is a serious issue for management offices. I would like to elaborate a little further on this point. Earlier, Professor Okada pointed out the need to look at the actual situation. When we look at the actual situation of management contracts and the actual situation of management offices, we ultimately come down to questions of fact-finding and interpretation. This can be done by disputing the factual findings and interpretation of the law in court, but this approach can take a long time to reach a resolution. Furthermore, especially for performers and creators, going to court can lead to negative rumors spreading, which may prevent them from getting work. These factors also make it difficult to bring a case to court. On the slide, I mentioned the issue of payment. There are a number of issues on this issue as well, but as time is limited today, I will not be able to give you a specific explanation of these issues. Next slide. The second problem is that the freelancer cannot terminate the contract. Our lawyers are often consulted by people who want to terminate their contract with the management office, but it is not easy to do so. Rather than being terminated, we are very often consulted that they are unable to terminate the contract and that they are in trouble. This is due to the fact that they are forced to sign a very unfair contract, which is concluded in a situation where they are not fully consulted. The Freelance Act says that the contract is to be concluded after adequate consultation, but the question is whether the parties in the weaker and stronger positions can adequately consult with each other. After consultation, they may say, "We don't need you in our management office. Please go elsewhere." Then, after being rejected by several firms, the person may not be able to sign a contract with any of them after all. If this happens, the person's dream of working as a performer or creator will be gone. So, somewhere a compromise has to be made. Given this, unless the industry as a whole changes, it is likely that grossly unfair contracts will continue to be concluded. Moreover, it is not possible to cancel them, and the contracts can continue for 2 or 3 years. This is a serious problem. To speak further, it is difficult under this Freelance Act to rectify the content of an unfair contract. When we, as practitioners, dispute a management contract or an advertising performance contract, we do not dispute it as a matter of the Antimonopoly Act or the Subcontract Act, but by claiming that it is against public order and morals under Article 90 of the Civil Code. By doing this, we protect the interests of the performers or creators by winning the nullity of the contract, thereby making it invalid. However, this can take a very long time if the case goes to court. However, I believe that, in this way, it is essentially necessary to rectify the contractual terms. However, I fear that the Freelance Act does not fully accomplish this task. It's already been 10 minutes and we have less time left. I'd like to finish in a couple of minutes. The next problem is that there is no legislation to ensure that people are properly paid for their work as remuneration. The Freelance Act does cover reductions in remuneration and buyouts. However, suppose, for example, that the contract states that the remuneration stipulated in the contract includes remuneration for intellectual property rights. However, it is not clear how much the intellectual property rights are worth. There is not a well-established practice in the industry on this point. I fear that if it is written in the contract that this remuneration includes the remuneration for the intellectual property rights, it will be difficult to discuss the matter, as how much the intellectual property rights usually amount to has not been established as a commercial practice within the industry. Thus, the first question is there an environment in which freelancers, who are in a vulnerable position, can fully consult? The second question is, how should remuneration, normally, be calculated? Unless these points are addressed, I fear that the situation will ultimately remain the same as before, even with rules such as the Freelance Act. I will talk about other issues. I would like to emphasize that there are a great number of minors, including children, working in the entertainment sector in Japan, as seen in the issue of Johnny's. I believe that they should be treated as workers and protected by labor legislation. However, in Japan, they are not recognized as workers. Sometimes they are recognized as workers and sometimes they are not, even at court. I had hoped for a solution to this problem in the Freelance Act. However, no provision was made for minors and children in the Freelance Act. I think this is very unfortunate. Overseas, there are laws that create special legislation and provide strong protection for underage workers, including minors and children. The fact that there is no provision in the Freelance Act in this respect is, in my opinion, clearly inadequate. Another issue is whether it is possible for a performer or creator who is in a vulnerable position and could be hung out to dry as a result of adequate and fair consultation and claims made in accordance with the law. In this regard, the media must guarantee that even if they do so, they will not be hung out to dry. Otherwise, in my opinion, the entertainers, creators cannot negotiate. For this reason, while I think there is a great deal to be solved by the Freelance Act, I think it is essential to go further in this area and create a law on entertainers and creators to protect their status and rights, as in South Korea, or create an entertainment agency, etc., and also to establish an education system for performers and creators. I spoke in a limited amount of time. That is all from me. Thank you very much for your attention.